Oh, controller?
Man, put your hands behind your back.
What? I told you she's lying. You're gonna arrest her for her lie. That's later.
Just put your hands behind your back. You're gonna be under arrest for DV.
I'm gonna get away with violating my due process right. Telling me I can't be at my house.
I am capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. I got the living man blues, yearning
And welcome
to be free.
to Facts or Frauds.
Cause I'm one of the people you see.
Your name, sir, for the record.
I'm up your Roman Sesticate Trust legal fiction corporate entity defendant. That's what you want to know. I am one of the sovereign people.
Yes. Okay. All right. So this is for Eric Joseph Martin. And officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay.
I object to that any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase R-I-C of the capital M lowercase A-R-T-I-N family, one of the living people living on the land, not the corporate entity defendant.
Okay, sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people of the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P86378, appearing on behalf of Mr. Martin, Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the bat. I'll move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the U.S. Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a U.S. Supreme Court case. Define probable cause as fact sufficient for the belief. There is no fact for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault.
Mr. Martin. Mr. Martin.
It's kidnapping.
No. What we're going to do, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing, and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm going to entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
It's arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just going to set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because the officer filled out the complaint form. He's lying by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't even be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of my due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been arrested. I should be here now. The charge is dismissed. There is no evidence here.
Talk over me, Mr. Martin.
My sister been caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed her. So she really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9 Clippard in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2, a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Man, they have they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're going to have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process. I can't live there because she makes up a lying allegation. I do not lose that right. That's my right.
You have a pre-trial that's scheduled for June the 23rd. You have a pre-trial scheduled for June 23rd at 9 o'clock. There is a no contact provision, and you cannot return to the Clifford location. And if you do, sir, that'll be a violation of your bond, and you will end up back before a judge in Taylor to address that. So thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is dismissed now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave the state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human right. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habit that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. I'm going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done. Thank you so much.
Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer.
48 hours later.
This is Mr. Martin. All right, this is 251756, the people versus Eric Martin. Mr. Martin, can you tell me your first and last name?
No, really don't want to give no name, so it's not fraudulent presumed on something else.
All right, well, I recognize you. You're Eric Martin. Sir, you've been brought to court on some charges here. Count 1 and count 2. The warrant alleges on June 12th of 2025 at property located at Clifford in the city of Taylor, a foreign complaint in this court was filed against you stating that on that date and location, the defendant, that's you, contrary to law, 1, did make an assault or an assault and battery upon the following person, Lisa K. Martin, contrary to MCL 750.81, parent 1. That's a misdemeanor punishable by up to 93 days in jail and up to $500 fine. He's already been arraigned. Yeah, he's just. Oh, so you know the original charges against you. And part of those charges against you, let's see, you could not have any contact with the complaining witness, Lisa K. Martin. You could not go to the address for Clifford, and you could not have any contact through the phone. You couldn't go in person. You couldn't go to the residence, period. And there's an allegation. I've got a report. You were arraigned on these allegations. It looks like on the 14th out county by Judge Burton. And then I have a police report that alleges on June 16th, Officers were dispatched to that location, and there are allegations that you entered the residence through the back door, and were actually in the home at time of arrest for violating your bond conditions. Those are the allegations against you.
Well, I move to dismiss the charges because the alleged bond conditions supposedly against me, which is really not against me anyways. Legal fiction, corporate entity defendant, which does not mean I'm a living man. But anyways, besides that issue, the bond conditions violate my right to be presumed innocent before guilty. Because I am presumed innocent before guilty, any bond conditions violate my right. Because if I'm innocent, then I cannot be told you can't do this, you can't do that.
So, Mr. Martin, are you entering a guilty or not guilty plea on that violation?
First of all, I'm not a defendant, so I'm not here to enter a plea. How can I enter a plea? I'm not the one charged.
Okay, then I'm going to say you're standing mute. It's my understanding you've refused to meet with counsel. You don't want an attorney. So I'm entering a not guilty plea on your behalf.
So, okay, well, so have you made the legal determination that I'm not guilty?
No, sir. I'm doing it based on your arraignment. You understand the allegation against you. Do you? I just told you what it is. The allegation is you violated a condition of your bond on an assault and battery domestic violence case by returning to the address after being ordered you could not return to the address.
Well, like I said, I moved to like I said, bond conditions violate the right to be presumed innocent anyway, so that's no true bond condition violation is legit anyways. And there's no probable cause for this case. I should have been arrested illegally anyways because there is no evidence. My sister lied. Her allegations are a total lie.
All right, you have a right to remain silent. Anything you say orally or in writing can and will be used against you, sir. You understand what the allegation is? You were just arraigned on it 2 days before picking up this, the original charge 2 days before picking up this violation. Mr. Martin, this is, I hear you. This is standard for you. And I honestly, you won't listen to court orders. You think they don't apply to you. You continue to go back to a residence you've been advised not to go to. You have a $25,000 cash or surety bond with a GPS tether.
Well, first of all, I don't have a choice. I have another house to go to for one. Besides violating my rights.
Well, now you do. Now you do, Mr. Morton. You've got another house to go to now. It's
guess what?
Jail. We'll see you at your next court date. All right, thank you, officer. We'll see you next time, Mr. Martin.
Goodbye, Mr. Martin. Okay, goodbye. Have a seat, Eric.
Day 3.
Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't even go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her. Did you swing at me before I kicked you? She answered no to that. And it was seen on the camera. She lied. This is especially why I should not be made to wait on this.
Mr. Martin, Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
Well, you're not being
answer.
forced to make any choices.
Well,
You can
I
have a
make one or
trial by.
two, so I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So, so you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Can you find
despite the fraudulent presumption otherwise.
Possible. All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even on a state date.
I want to make clear, I'll point out, it's supposed to be 28 days, and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific, under the court rules, it should be 28 days without excluding Saturdays and Sundays or legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, msachar 6.004C, and also msachar 1.103, the applicability rules, that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-. 1756-SM.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody, because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gizicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gizicki has indicated for the record he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said. Your statement about there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before, and there is no evidence at all. We have no case. There's no evidence, and that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, it's a misdemeanor, so we're not having a preliminary exam. We're having a bench trial, and the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this. If you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
You haven't let me finish. You haven't let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against me. Somebody have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be. Come on, let me finish.
Okay, denied.
The case should be dismissed now.
We'll see you back on your trial date. Have a good day. Okay. Thank you, Mr. Gizicki.
Good morning, Your Honor. Not to me, as on behalf of the people, B88493.
James Gizicki, on behalf of the defendant.
Mr. Martin. All right, Mr. Martin, can you tell me your first and last name?
First, I object. I'm not the defendant here.
Then I'm going to issue a bench warrant for your arrest. You're here. I'll recognize you. You're Mr. Martin. Okay. I understand. Let me ask a few preliminary questions. I know, Mr. Gizicki, you need to make a record. Is the complaining witness present for today's bench trial? Okay. Okay, thank you.
Two issues. One on discovery. We were here about 2 weeks ago. I did receive discovery. I believe it was like June 23rd or so on. I've been on vacation since the 3rd of July until yesterday. I had no opportunity to go down to the jail to visit Mr. Martin. But with, today, I handed him a redacted copy because according to the discovery procedures in Wayne County, The only files I can share with the defendant are redacted. As far as the video goes, I have no other means to, redact that, to show that, or to give him a copy. Today I handed Mr. Martin a redacted copy of the police report that I did have. Okay. With that aside, Your Honor, I do want to make a motion to withdraw. I have had contact with Mr. Martin in the past and ended up with the same position I am right now. There's no communication between the two of us. There's, different thoughts on how to proceed and so on that I cannot adhere to. So I'm asking the court to withdraw on this matter.
Mr. Martin, have you had a breakdown with your attorney?
No, he's not doing his job. So like as he admitted, he has a problem with discovery. So I just told him I'll file a motion to dismiss the case, then based on the ineffective assistance of counsel.
Okay, well, you can't dismiss a case on that. I'm asking you a specific question as it relates to Mr. Gizicki. Do you want him removed from your case?
As long as he's not going to do nothing that's going to jeopardize the case further, like try to delay, like he asked me, do you want to do adjournment? I said, no, I'm not doing no adjournment on the trial. I'm going to just sit in jail while I'm waiting. So I don't consent to him doing nothing that's going to jeopardize or violate my rights. But as long as he's doing, what he's supposed to besides it, I have no problem with it. But
well, you understand, Mr. Martin, I've told you this previously. Attorneys it's against the court rules for them to file frivolous motions. So Mr. Gizicki cannot, as your attorney, make motions that are frivolous. And some of the motions that you've previously presented to this court are in fact frivolous. Okay, I have jurisdiction. So if you're asking Mr. Gizicki to file a motion on the basis of jurisdiction, he cannot do that. Do you understand what I'm telling you?
The one I didn't ask him to file a motion specific to no jurisdiction.
Well, you've asked him to file a motion to dismiss today.
No, I didn't ask him. I just told him I was going to do it myself. I was going to file the motion to dismiss the case because of this ineffective counsel not providing.
Okay, that's not a reason for a dismissal.
Sure.
Okay, so Mr. Martin.
I'm going to move. Well, if it's right now, I'm going to move for that. That's why we're talking about it. Or
okay, later. Denied. What's your next one?
Based on what reasons?
Okay. So do you want Mr. Gizicki to represent you or not? Yes or no?
I'm going to say no.
Okay, there's been a material breakdown of the attorney-client relationship based on both counsel and Mr. Martin's assertions. So Mr. Gizicki is withdrawn from the case.
Thank you, Your Honor.
Yep, thank you. Now, Mr. Martin, you have to make some decisions. Do you want an attorney appointed to represent you on this? I know
unless one's immediately right now, no, because I'm not going to allow a delay in this case due to these independent attorneys not doing their jobs constantly.
Mr. Martin, you have a constitutional right to an attorney. If you can't afford one, I will appoint one for you. Do you understand that?
I comprehend that, yeah.
Okay. So here's the thing. I don't want you to say that you don't want an attorney because you want to go to trial right now, unless you have a true understanding of what that means. Because you can't go back later and say, well, now I want to appeal because I wasn't given counsel because I said I didn't want counsel because I want to go to court right now. Do you understand that?
Well,
I'm happy to adjourn this for a week so that you can have an attorney.
Why I sit in jail? No, that's why I don't agree with that. So no, I can present myself fine. I've been doing all 30 years studying, practicing.
Well, it's not been going very well for you, Mr. Martin. It might be time for you to get an attorney.
No, I don't agree with that. I've been being several cases myself.
Okay.
So regardless of that, this is a simple case anyways.
All right, Mr. Martin, listen to me. You understand. I want you to understand a few things, okay? Again, you have a right to an attorney at public expense. We could expedite this case and put it on a docket right away. It's a bench trial. So I could get you on, next week or later this week. I'm not certain if that's possible. It would likely be next week so that you could have a lawyer and that lawyer could represent you. And I want you to think about that, because Mr. Martin, if you have a constitutional right to a lawyer, or to represent yourself if that's what you want to do. But I need you to take the passion out of it, take the heat out of it for a minute, and think about what you want to do as a smart decision. Do you want to wait a week for a trial and have an attorney present, or not?
No, I don't want to delay this, because there's no guarantee the next attorney may do the same thing. Just keep on not doing their job, and then think they're going to delay me. So no, I'm ready to go forward. And I have.
You understand, Mr. Martin, that if you chose to represent yourself at this hearing, you're held to the same standards as an attorney. And do you understand that?
No, objected under Haynes versus Kerner, U.S. Supreme Court case. Pro se litigants are held to less stringent standards than formal pleadings drafted by lawyers.
Okay, well, this isn't a formal pleading. These are questionings of witnesses. Well, no, it's not the same. I want you to listen, Mr. Martin. I'm trying to make sure your rights are protected right now. I'm asking you to get an attorney. You've indicated you want to proceed without one. And I'm asking that you understand I'm not going to allow you to get up here and ask questions in a way that are inappropriate to witnesses. You can ask questions, you can get answers, you can ask more questions, but I'm not going to allow this to meander into something that it's not. Do you understand that?
Well, I do my best. If it, do something, that comes that you let me know or whatever. But of course, I know the basics of presenting a case, be it criminal or civil. So,
Did you go to college for 7 years to be a lawyer?
Not official college, but when I was in prison 24 years, I studied the law library for 24 years straight. Okay. 30 years now counting, so.
Okay.
There might be
That's
a few
your
things
choice.
I might forget.
If that's Mr. Martin, I'm not, look, you and I have gone back and forth for several hearings at this point. I'm not going to change your mind on things. I know that, right?
Right, yeah.
You have a right to a trial. You have a right to a trial by jury or judge. You've previously waived your right to a trial by jury. Is that correct?
Right, yeah.
Okay. And so
since I'm not going to get a jury by like I really want, a jury of my peers to be those of the sovereign people, since that was denied before Slaton's court. Same.
Yeah. Do you know where am I supposed to go to get a judge of a jury of sovereign citizens? I mean, that's not how it works. That's not what the Constitution requires. So you're waiving your right to a trial by jury, correct?
Only because, like I said, I can't get a jury by my peers of sovereign people. So.
Oh, okay. And are you waiving your right to an attorney?
As of now, but let's say, worst case, let's say even though I shouldn't, there's no evidence, even if it was to be guilty, I would then want an attorney to represent me on appeal. I'll say that. But
okay, well, I want you to know that you would have a constitutional right to have that attorney too.
Right.
And if
as
you're
of
found,
now, no, because these attorneys keep, like I said, they keep doing this. It's constant.
Okay.
That I've been having, not doing their job and holding me up. I'm not.
Okay. All right. Is there another Officer Frisky? Officer Kemp, can you come up for a second? If you can stay with the prisoner.
But also I need
give me a second, okay?
Court case law that supports that. Me not being at home, able to get that U.S. Supreme Court case law. I don't have it with me now, but
would you like some time? Would you like me to adjourn your trial for a week so that you can adequately prepare for this hearing?
If I could get on a bond and go back home like I should, then
no, you're not allowed back home. I've already said that.
Well, that's why then I'm not going to allow that. No.
All right, then that motion's denied.
Well, let me mention this then, as far as U.S. Supreme Court case law goes. If I remember right, Will versus Michigan State Police, I believe is one of the U.S. Supreme Court cases that support person. Does that mean one of the people, the sovereign people? So you might want to look in that, and I know there's another one that's a little more I like better. I think it was U.S. versus Williams.
Mr. Martin, what's your point?
My point is the same. It's just I want to give reference to the laws that support it. That I'm going off the top of my head. That, like I said, I don't have access to my notes at home, so wasn't able to. So, but I know it says it because I read it myself. I copied out the law book. The same someone told me.
Okay.
Might want to look into that one, but all right, and I think that's it for motions for now. I still reserve my right for others that may come up,
Okay. Well, you've made your record of what your motions are. you have my rulings, and you of course will have the right to appeal anything if you need to do that.
Was this started at all this morning?
What's that?
Was this case started at all this morning?
All we did was he made his motions for dismissal.
Okay.
Yeah, and now we're ready to actually like start the trial.
Okay.
Unless he has more motions for dismissal, but after that. I want to apologize for the wait we had there, Mr. Martin. Did you have a chance, Mr. Martin, to watch that video?
I've seen the videos that, of the cop going in my house.
Okay, so
But
you,
there's still, but not the video of the other court case my sister.
well, I told you I'm not entertaining video from another court case.
You go attacks her credibility, but yeah.
Okay,
Okay, well, anyways, yeah, on that, but, there's something.
okay, well, wait 1 second. Can I get your appearance, counsel?
Yes, Your Honor. Good afternoon. Natsamelia Asmer on behalf of the people, P88493.
Okay. And, Mr. Martin?
I missed her, but, object to the mister, because the mister will understand what, understand, but
Okay. What's your first and last name?
it would mean that I'm, not one of the sovereign people, and I am one of the sovereign people.
Okay, well, you're also a citizen of the United States, and you have a birth name, and it's Eric Martin. I'm familiar with you all except your appearance. All right, any other preliminary matters before we start testimony?
No, Your
Yes.
Honor.
All right, go ahead, Mr. Martin.
Yeah, some motions, but, one of the things I need I need someone to testify for, and that's the tax assessor, Jessica here, that's next door, which supports, my sister being a liar.
All right, that's not relevant.
Her not lying is not relevant, that doesn't make sense.
You can ask her questions about
No, I'm not
that.
talking about my sister, I'm talking about the tax assessor will admit something, if she's questions which the quickest, easiest way would be like you call her, or I need to call her, subpoena her in the court to testify to something, which will.
Give me an offer of proof. What is she going to tell me?
She's gonna say the house's name, the Clifford Street where we live at, that house is in my father's name, which this is what Jessica told me. This would support my sister's lie, how she keeps on saying, it's my house, it's my house. She's on the video saying that 1,000 times.
Okay,
So that would attack that she's a liar, which would attack her lying allegations in this complaint that she's a liar, and therefore it's relevant for that.
ma'am, can you stand and tell me your first and last name?
Lisa Martin.
Miss Martin, is the house in your father's name?
Yes.
Okay, that's it. That's all I need to know. All right, I'll take judicial notice of that,
Okay,
that
thank
the
you.
house is in your father's name. Anything else?
No, not as to that, no, actually, no, I have some motions now, yes, besides that.
All right, Mr. Martin.
And, okay, I move to dismiss based upon, my right to slavery, against slavery, that is, under the 13th Amendment, these proceedings from the jump have been proceeded against my consent. I never consented. If it's ever fraudulently assumed I consented, again, it's fraudulent, and it's not true, and therefore violates my right to slavery.
Okay, denied. Next. Mr. Martin, I'm going to start taking testimony soon. I've entertained about 10 motions to dismiss from you already this morning, so.
I think I have one more. No, that's about, I have one more. That's all I can think of right now. I reserve my right to bring it up again if I think of it.
All right, at the end of the prosecutor's case, you can bring a motion if you have one, okay? All right, any other preliminary matters?
No, Your Honor, I did just want to place on the record that I did show all the digital evidence that we have in our possession to Mr. Martin.
Okay, he's indicated on the record that he watched those videos.
Yes.
So, okay, call your first witness.
Thank you, Your Honor. The people call Lisa Martin.
All right, Miss Martin, come on up to the witness stand here. And Miss Martin, when you get up here, I need you to stand and face me, okay? Now, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, if you can have a seat in the witness stand. Is Lisa Lisa?
Yes.
All right, you're a witness.
Thank you, Your Honor. Good afternoon, Miss Martin. I want to direct your attention back to the date of June 12, 2025. Do you remember that date?
Yes.
Okay, and on that date, were you at or near the location for Clifford?
Yes,
Is that in the city of Taylor, County of Wayne?
yes,
And what's at that location?
my house.
Okay, and who lives at that location?
Well, it's my house. Both my brothers live there. I've
Who are
given
your
them an
brothers?
eviction notice.
Who are your brothers?
Eric Martin, and I have another younger brother, Kurt Martin. They both got served eviction notices. They're supposed to be on October 17th, and they ain't out.
Okay, and Your Honor, the witness did point to Mr. Martin seated at the defense table with the, let the record reflect that the witness has identified Mr. Martin.
Do you have any objections to the identity of you?
Well, just the same objection from the jump that I'm not the defendant, named in the complaint. It has a similar name to me.
Okay. All right, it's admitted. The record shall so reflect.
Thank you, Your Honor. Okay, and on that date, June 12, 2025, did something happen that day that brings you into court?
Yes.
What happened that day that brings you into court?
I was sitting at the kitchen table on my phone. My brother came through the back door.
And when you say your brother, you mean Mr. Martin or?
Yes.
Mr. Eric Martin?
Yes.
Okay.
Came through the back door, walked past me, went over to my little radio that I listened to. There was a volume level from 0 to 10, it was on 2. Okay, just goes up to it, turns it down. He does this like 10 times a day. Turned it down, walked in his bedroom. I walked down the hall, stood at his door, and I said, you don't touch the radio. He goes, get out of my room. And he charges toward me and pushes me.
Where are you standing?
I'm standing right at the beginning of the bedroom.
Okay, like behind it, or are you in the bedroom?
No, I'm not in the bedroom. I'm standing right outside of it.
Okay, and Mr. Eric Martin is inside the bedroom and he charges at you?
Yes, yeah. He's at the furthest part of his bedroom, so about 7 feet away from me. And he said, get out of my room. And then he comes toward me and shoves me, knocks me off balance. I didn't fall. And then he pushed me again, but his hand like hit my neck right here. It was like a karate chop, but he didn't like try to karate chop.
All right, next question. You got to let her ask a question. She'll ask you, and then what happened? And then what happened?
Thank you. So you stated that you were knocked off your balance. How were you knocked off your balance?
When he shoved me.
And you're making this motion, did you use both hands?
And the record shall reflect she's got both of her hands held up and pushing them away from her at shoulder height.
Thank you, Your Honor. Okay, and did you fall on the floor?
No.
Okay, and then you stated he tried to do that again?
Yeah, he tried to like push me again or something, but his hand like went like this. So I don't know if it slipped, but it hit me like right here, and it hurt for a little bit, but I didn't. I was fine.
A record shall reflect the witnesses pointing to her neck area.
Thank you, Your Honor.
And then that was that. Okay. And I told him, I said, you don't learn about putting your hands on me. That was the 16th time in 4.5 years that it's been my house that he's put his hands on me.
Did you allow that sort of touching, that being shoved and?
No,
All right, and just for the record, I'm not accepting the prior instances or allegations of prior instances, so that's stricken from the record.
Of course, Your Honor.
Go ahead.
Okay, and did you sustain any injuries at all?
Yes.
Okay, and what kind of injuries did you sustain?
A couple of days later, I noticed when I was getting dressed to go to the store that I had a bruise on my arm. So I took a picture of it, a couple of them, and then in a week or two later, it was still there, and I took pictures of that, yeah.
Okay.
And the bruise just went away 5 days ago, so it was there for 3 weeks.
And would you recognize those pictures if you saw them here today?
Yes, they're my pictures.
Okay. And Your Honor, may I approach the witness?
Yeah, are these proposed exhibits?
Yes, Your Honor.
What are they?
They are
1, 2, and 3?
proposed 1 and 2.
Proposed 1 and 2. Okay, you can approach the witness.
Thank you.
Just show.
I'd like to get a copy of those too.
You have a copy of those, Mr. Martin.
I don't know, papers, what do you mean?
I thought those copy photos were.
I can show you 10 pages, I got it on.
I was provided with copies. I left them in that room because half of the picture was chopped off.
Okay. I'll get you a copy.
And then may I approach the
You can
witness?
approach.
Thank you. Starting with people's proposed exhibit number 1. Do you recognize what I'm showing you?
No, that's my arm.
Okay, and,
It looks like a foot, but it's my arm.
okay, and do you recall what day this picture was taken?
Yes, there's dates on the pictures. It was taken on the 16th.
Okay, and does this photo appear to be manipulated, changed, or
No,
altered in any
I
way?
don't even want to do any of that.
Okay, and Your Honor, moving to admit people's proposed exhibit number 1.
All right, does that accurately reflect the way your arm looked on that day?
Yes.
Any objections, Mr. Martin?
Yes, I object to the pictures being admitted based on, prosecutor told me, as I asked her, when was they taken, prosecutor admitted it was taken 4 to 7 days later from the alleged, this allegedly happened.
All right, she
And
alleged.
based on the timeliness of it, I moved to dismiss it.
All right.
This violates my due process right to fairness. To
Okay.
timely.
Mr. Martin, the witness just testified that photo was taken on June 16th, which would be 2 days after the alleged incident. So that's her testimony.
They should have been taken immediately. And the
Do-
prosecutor, the disputes like this, what the prosecutor told me, it was 4 days to 7 days later. She told me.
Okay, do you have any other objections to the photo being admitted?
Besides the timeliness, it's not a current, well, I mean, it's not true.
Okay, okay,
That's-
it's admitted. You can
For my argument.
ask questions about the photos, but the photo's admitted.
Thank you, Your Honor, and for the record, the date of incident was the 12th of June, and the photo was taken on the 16th, so it was 4 days after?
4 days after, okay.
Okay, and then do you recognize, I'm handing you it's marked as people's proposed exhibit number 2 as well. Do you recognize this photo?
Yes, that's my bruise still a week or 2 later. It's still looking like that.
Okay, and do you recall the date of this photo?
I think it was 23rd,
Okay,
22nd and 23rd.
and did you take this photo?
Yes.
And does it at all appear to be manipulated, altered, or
No.
changed?
No,
Is that-
no, I took the photo.
And is that the same as how it looked on that day
Yeah.
it was taken? And Your Honor, the people are moving to admit people's proposed exhibit number 2 as well.
All right, do you have the same objection to the admission of this photo, Mr. Martin?
Yes.
All right, it's noted for the record, they're admitted over objection. 1 and
you,
2
Your
are
Honor.
admitted.
And Your Honor, may I publish the photos to the court as well?
You may.
Thank you.
Okay. Ma'am, can you tell me where on your arm is that injury at? If you could just point to your arm, where is that?
It was right here.
All right, so in between the elbow and the shoulder.
Yeah,
On
it looks
the
like
interior.
a foot because my arm fit's hanging, but that's exactly where it was. See how it hangs?
Okay,
It was right here.
all right.
And
Record
you
should
can see one
indicate,
of my spots in the picture too. That's where it was.
all right, record should
And it just
indicate.
went away.
Miss Martin, let me make the record here. Record should indicate that the photograph, the witness has indicated that that is her left arm in between her elbow and her shoulder blade on the lower portion of her arm.
Thank you, Your
Or
Honor.
interior portion of her arm, we'll say. Okay,
And then, Your Honor, this is people's exhibit number 2 from the 23rd.
okay, same area and location as the first
Right,
photo.
Yes, Your Honor.
It's still there.
And Ms. Martin, the photos that you were just shown, was that you stated that that was the left interior of your arm. Was that the same, was that the same area that you were shoved in earlier on that day? On the 12th?
Yeah, when I was shoved, like I said, it takes a while for a bruise to appear. It doesn't appear immediately.
Okay,
So when I noticed it, that's when I took the picture.
okay, and what happened after this incident?
What happened
After you-
after he pushed me?
Yes.
Well, after he pushed me, I said, boy, you got your nerve to put your hands on me again. You don't learn, do you? And I called the cops and it took about 25 minutes for the cops to get there.
And did the police arrive?
Yeah, about 25 minutes later, and the whole time he's yelling at me from the bedroom, calling me names, laughing, thinking he's gonna get arrested, whatever. I ended up going on the porch because I didn't want to hear him because that's all I hear every day, all day long.
Do you remember what he was saying?
Nothing I could say in here, just the
You
usual.
can say it in here, it's a court of law, ma'am. If you remember what he said, you have to say it.
Swearing, calling me names, you know,
What kind of names?
I'm lying when I never told a lie in my life, but I lied.
What kind of names were you being?
I don't even remember. I'm so used to this every day in my home. I ended up going on the porch waiting for the cops to come. They came, they asked me what happened. They went in the house. They called him out of the bedroom. He came down to the end of the hall. They asked him what happened.
And were you present when they were questioning him?
Yes, I was standing in the kitchen.
Okay, do you recall what he said?
Well, what happened was the cops asked him what happened. He said he turned down the radio because it was cat abuse. And then he told the cops I was lying. And then when I heard that, that's when I opened my mouth. I said, I'm not lying. I don't lie. And they're like, okay, be quiet to me. And then they arrested him. And of course, as they arrested him, you know, what's your badge number? I'm gonna get you guys fired. The usual. And they just laugh at him and laugh out, yeah.
All right.
And that's it. And they took him.
All right, thank you, Ms. Martin. Nothing further for this.
All right, Mr. Martin, do you have any, let me ask you this first.
Examine her arm though too.
Do you want to what?
Examine her, make sure, you know, it's where they're at supposedly.
Well, they're not there anymore. She's shown us her arm in court. But I'll have her do it. Ma'am, can you just show your arm again? Where you had
Where it was?
Where the bruises.
What?
Don't talk to him.
I will stand
Wait,
up.
hey!
No, I was just saying I'll stand
No,
up.
shh, quiet. Just listen. We're gonna get through this. Lift up your sleeve and show me. All right, see that, Mr. Martin?
Right here. There's
I'm
my
really
arm
careful
hanging.
here.
It was
I'm
right
really
here.
All right, thank you, ma'am. Listen, I'm gonna tell you two right now, we're not arguing back and forth. He has a right to ask you questions. Just do your best to answer his questions so we can.
Oh, I was just standing up. I wasn't arguing.
Okay, I know, but I'm just, see, like, just, okay, go. Mr. Martin, what's your next question?
No, before I get to the question, I want to examine the arm closely.
I'm not gonna allow you to, Miss Martin, stop. I'm not gonna allow you to go up to the witness and examine the arm closely. She's shown it. I'm the trier of fact. I've seen her arm. I've seen it. What's next?
For the record, I can't see from this distance. So.
Okay, well, I'm not gonna allow you to approach the witness like that.
All right, well, anyway, now the videos, I want the court to review the videos. I don't want to get to that yet before, you know, after the question, whatever, but I want the videos reviewed in support of my arguments now, where the cops entered the house. That's actually only one video, so.
Are you moving for the admission of a video?
Yeah, but when they came in the house.
Is there a body worn camera video?
There is a body worn camera on the interior of the house.
How lengthy is the video?
It's not that long.
Do you have any objections to the admission of that video?
I have no objection to it.
All right, this is stipulated exhibit 3. If you want to, you can put it on Zoom if you want. If you just want to, if you're in the Zoom, you could just share screen. And then I can see it and the witness can see it and defendant can see it.
Your Honor, there are multiple videos. If I may ask which one he is referencing to.
I think it's the 5-minute one with just entering the house. I think there's only one on that. The other ones are
the squad car?
Yeah.
Okay. I'll let you into Zoom when I see you.
What's going on?
Orange.
Good. How did you get in? Okay. Okay.
Can I say something?
No, she asked if she could say something. I told her no.
That's not from the night.
And she's correct, Your Honor. This is from the 16th. So this is not the video, the 5-minute one he was referencing.
Okay, that's when he violated the bond.
believe this is the correct video from 12, Your Honor. I'm playing from 00.
Okay. Mr. Martin, is this the video you're looking for?
Take a look.
Well, no, look on the TV screen. We made it real big so you could see it.
Okay, well, they're not in the house yet.
Well, they'll get there.
Yeah, I know you guys. She likes it, and then she know what happened. I heard.
Your Honor, I believe this is the wrong video as well.
Yes.
But there's another one I do want to look at. Well, yeah, I still want to use that one too as support, but keep going just until my brother gets done saying something and original stuff. This is over to the case to go ahead and keep going a little bit.
Okay,
This one's 31 minutes.
If we could skip ahead to the.
Yeah, you want to see what happens, what you want me to see what happened in the house. Is that correct, Mr.
Yes,
Martin?
I'm saying, but as she was playing, I just want to go further, keep playing that when you just play my brother. He makes a statement. I just want to go to there, then stop it, and then go to that video. But I want to play that one.
Well, this is the one that's admitted. This is the one you wanted. So let's get through this and then you could try and move for the admission of another video. But let me see that. And just for the record, this is Exxon body cam 6/12/25. It looks like it's hours 22-27-44. So we'll start with this one. And if you want to fast forward it to
And for the record, that's at 1:39.
Okay.
You turn it up, it's way too low.
Can you make the audio any louder?
That's as loud as it's going.
There's no way to connect to the speakers in here, huh?
No, because of the feedback.
Oh,
Do you want me to just watch the videos?
Yeah, if you can do that, then yeah, I guess that would be better.
Can I see the computer so I can see the audio?
Yes, Your Honor.
Or so I can hear the audio?
Video's not already 31 minutes.
This is number 16. Hi, today. This happened since it's been my house for 5 years. Punched me. That choked me a little. Was it nothing major? Like I'm not hurt or nothing.
You feel like you're gonna lose consciousness.
No, but I'm like, fucking touch me. Oh, I can lie and say, touch me. I said, I'm a fucking lie. I don't call the cops on you, Eric, unless you put your hands on me. Then, oh, shut up, that bitch. Shut up, that bitch. Say, no, bitch, I'll do what I want. You feel like that's simple. When he walked past it, and I said, oh, I said, I don't know where you got this.
Okay, so he's like, he pushed you.
Yeah, because he's also put his hand on my face before.
Church.
Yes, my dad has never, 50 years of marriage, put his hands on my mother. Yeah, yeah, he's got a rap sheet of tail like this. You guys should know him. You know,
Police. Eric, come out here. Come talk to us, Eric. Yeah, Jesus is lying. She's trying to just. All right, what's going on tonight, man? Well, I was turning the radio down, and the kitty girl, the cat, always lays by the radio. I turn it down so she's not doing her cat abuse by turning the radio loud in the ear. She don't hear. It was like this. He always says this. Just let him talk. So I just turn it down so it's not blasting her, and she gets all emotional about it, tries to control everything. She lets her emotions go wild. It's usually. Just let him talk. You already talked.
My house.
Ma'am.
I know.
Outside. Outside.
No, I'm trying to get out of bed all day.
I'm trying to hear this side of the story.
I'm just saying.
Ma'am.
He touches it 10 times a day.
Stop talking over us. You sit outside so we can talk. No, I want you, but
yeah.
Try to get your side of the story. Ma'am. Anyway, so that's I turn the radio down. She goes wild and crazy, and that's it. Tells a lie about I assault her, and she's telling a lie. And I want to mention she tried to do this shit before. Total lie in court. It is on camera. The judge, prosecutor, for example, she's seen it me before, right? What happened to them? And she lied. That was it.
Never told a lie in my entire life. Okay.
You need to stop.
Just believe I've never told a lie ever.
You need to stop right now.
Well,
you see how she's crying out for emotion. All right, you're both concerned. I'm going to put it back. I told you she's lying. You're going to arrest her for her lie. That's weird. You're going to get arrested for DV. You can't arrest someone for someone tells a lie. Tell me she lied. Stop talking. What is your name? Officer Buford. Okay, you're going to lose your job. Okay.
Yeah, everyone's going to lose their job.
You don't have the right to arrest people who don't have that. No, they don't have to. You're violating due process. She lied before, and it's on camera.
I've never lied a day in my life. So how would I lie? How do you know?
The building's already shot. It's in the court. She lied before. We're going to take a walk through it. What's up? Yeah, right here.
Both my brothers are evicted. They should have been out of here 7 months ago. I shouldn't have to put up with this abuse.
He's going to jail tonight, ma'am.
I know he's going to jail, but I just, yes, I'm just sick of them saying, oh, she's lying. I have never told a lie in my entire life. But that's what they both say.
We're not pressing you about that.
I know that, but
what's your first name, man?
Lisa.
What's your middle name?
K-A-Y.
What's your last name?
Martin, M-A-R-K. Oh, there.
What's your name?
Job.
Ma'am.
Oh, he's wrote 1,000 lawsuits.
What's a good phone number for you?
7348.
I'm just skipping that ahead.
Yeah, that's
Second.
good. That's the part. Okay, that's further up as I was relevant.
He does that, he unplugs my phone line 10 times a day.
That's all you wanted me to hear on that? Okay.
May I approach on?
You may.
Thank you.
And I,
All right, hold on.
okay.
Hold on. Mr. Martin, you're cross-examining the witness. So, okay, now you've had me see the video. Do you have any questions for the witness?
Yes, but I just want to point out in case, want me to do it.
Well,
before.
that's safe for argument. Mr. Martin, you get to make your legal arguments or your factual arguments at the end of the case. We're in cross-examination. So I've watched the video. It's been admitted. Do you have any questions for the witness?
Yes, I do. I'm just saying I want some more motions to make that remember
Okay.
to dismiss.
No, go. Ask her questions.
All right.
Stay right here.
Yeah, Mr. Martin, stay there, but you can ask questions. There's a microphone right there.
I was one to the podium. There's no usual procedure. All right, you made a statement before, true, that I don't know the law. True or false?
True.
Based on what?
You don't know the law. All you do is break the law for 40 years.
So what is that statement based on then?
I have advice for relevance.
It's irrelevant. Next question.
You said the house is yours. You said that several times.
Yes, it is mine.
Your Honor, I object to
But it's
relevance.
not in my name. It is mine. I have the will to prove it.
And I've taken judicial notice that the house and the city of Taylor is under your father's name. Both parties agree to that. So next question.
Okay. You made the statement that I've been evicted, true or false?
Yes, you
Your
got
Honor,
served.
again, relevance.
How's that relevant, Mr. Martin?
Attack her credibility.
All right, go ahead.
And, well, has any formal proceedings been filed in court ordered by a judge that?
Well, those are two different questions. So wait, if he's gonna try and attack her credibility, the first question was, you asked you asked her what, if she had ever evicted you, right?
Well,
So
probably.
let her answer that question, yes or no?
Yes, he was served an eviction from here, you know, you get the paper. He was
Okay.
served it September 17th.
All right,
He was supposed
one
to be
sec.
out October
Oh, next question.
Has the judge ordered me evicted, yes or no?
No, you did not get out October 17th and you haven't left.
Have you filed official paperwork in any courthouse, or this courthouse?
Judge, I don't see the relevance.
Let me I'm giving him some leeway, he's in pro per. I don't know where he's going with it, so I'm gonna allow it. Go on, Mr. Martin.
Have you filed any paperwork in court that actually got me, or that caused me to be evicted, yes or no?
Yes, I went to the court window when you walk in and go to the right and got the paper for the eviction, filled it out, handed you the copy. I have the other copy. You were supposed to have been out October 17th.
So did you initially, officially file it with the court clerk, yes or no?
Yes, I got the paper from the court clerk.
And do you have any proof of that, like stamp?
You have the copy, I have the original.
But no, okay, well, anyway, so no judge issued an order, you said again, right? No judge issued an order.
No, I did not see a judge.
Okay. I didn't ask, did you see one? Did one issue one?
Well, it sounds like maybe she filed a 30-day notice to quit and gave you notice, but then an eviction case was not brought because you never saw a judge. Does that sound about right? Okay, next question. I got it.
Is it true you said in the videos several times you never told a lie in your life?
That's right.
Now you say I pushed you. How many times did I push you?
You already heard that.
Answer the question, ma'am. No
Twice.
argument.
And where in the body was that, supposedly?
Obviously on my arms, since I have a big bruise for 3 weeks. And then the second time, like I said.
Well, the picture's not clear. I see the point in this area around the left shoulder. The other picture's unclear. Where on the
Judge,
body
I
that's supposed to
object
be?
and ask that defense formulate his statement in a question.
Yeah, you have to ask questions. You can't just
I did.
you're testifying.
Where is it on the body? Where is it on the body? Besides the other one that was by the left shoulder, I'm asking her, where is the other supposed bruise, or what do you call it?
There was only the one.
So now there's one.
All the pictures are of the same bruise.
Okay, I understand. Next question.
Is
Mr.
it-
Martin, she testified that one of the bruises, the first picture was taken on the 16th of that area on her arm. And then she testified the second photo was the exact same area on the 23rd where the bruises were still there. That was what she testified to.
Yes.
Okay, isn't it true that you have been bit by some type of bug causing these?
This overruled. Go ahead.
Hurt my gosh, I don't know.
No, she's got a right to do that. She's a prosecutor. She's objecting to irrelevant questions or questions she believes are irrelevant, that she's doing her job. But I'm giving you leeway to see where you're going.
I think they're a little too quick because I didn't hear me out.
Okay, go on, Mr. Martin.
But isn't it true that you've been bit by a bug before, causing you to have a skin condition in your
Yes.
arms?
Scarred, yeah. My arms are scarred. And bottom of my legs. What is that guy with it?
Well, I'll get to that in argument, but, okay, that's the question. Thinking other questions. Okay, so is it true that, I turn the radio down? I guess you admit that, I guess I don't need you to, you already admitted, you turn the radio down. Isn't it true that, Kitty Girl the cat was laying by the radio when I turned it down?
I don't remember where she was at. It's none of your business to touch my radio. If it was on full blast, it's none of your business to touch it in my house.
Just answer the question. Do you remember the cat being by the radio, yes or no?
No, I don't.
All right,
remember the
next
cat.
question. She doesn't remember. Next question.
It was on volume 2.
No more. Next question. It's irrelevant. Quite frankly, whether or not the cat was by the radio means nothing to me as a trier of fact. Next question.
He knows the law.
I know, but you don't know how to be quiet and answer questions.
I'm answering them.
Ma'am, do not respond to me again. If I ask you to answer the question and then quit talking, just quit talking. Next question.
Do you have a receipt for the radio since you allege it's your radio?
Irrelevant. Next question.
I object to you saying it's relevant because
I don't care. I'm the judge and I said it's irrelevant. Next question.
Is it true that a case was dismissed before where you testifying that you never swung it?
That you never what? I just didn't hear you. I just
asking her, has a case been dismissed before with me that you tried to bring against me, alleging I attacked you? And I asked you, did you swing me before? And you said no. But the judge has seen on the video that wasn't true.
Judge, I'd object to relevance on this as well.
Oh, I can explain that.
All right, well, let's, I don't know if it's relevant or not.
It's not.
I mean, does it go to her credibility? Maybe. So I'm gonna go ahead and explain it.
I've never swung at him, for one. This video he's talking about, the first time that he didn't put his hands on me, he kicked me in the stomach back, and I called the cops. We had a Zoom meeting with Slavin on that. I couldn't do Zoom at that time on my phone. My boss let me do Zoom on hers while I was at work. I went in the conference room. I let them know that this phone's gonna die any minute. They said, if it does, call this number back. So as he was representing himself again, asked me a question, something, the phone died. I called the number right back and they said, the judge dismissed it. I said, how? He kicked me in my stomach for no reason.
Okay.
And they said he showed a video to the judge. Well, there's no video of me ever coming at him. So what he showed, he basically committed perjury. He showed a video of years ago when he grabbed my wrist so hard and I had to fling my arm like loose. That would be the only video that he could have shown Judge Slavin for him to dismiss it.
Okay.
That had nothing to do with him kicking me in my stomach of what the incident was about.
All right, Mr. Martin, next question.
Is it true that after I turned the radio down, that you went to my room getting in my face?
No, I didn't even walk in the room.
Wait. Okay, that was her answer. Now, what was your next question?
Did you go to my room after that? Told me he was going to go to my room, invest with something in my room after I turned the radio down. Did you do that?
I didn't even go in your room, which is really my room because it's my house. But no, I was on the outside. You said, get out of my room, charge toward me, and that's when you pushed me.
No more questions that I can think of right now.
All right, any redirect?
Just one question. Ms. Martin, could you have gotten that bruise any other way?
No.
Okay, you
I
wouldn't
never
have
left the
or
house.
anything?
Never left the house. Didn't even vacuum out. Think for a couple days. No.
Okay, nothing further.
Okay, so witness, do you have
Excuse me, yeah, just
recross?
some
Okay.
more questions. Just
Go ahead.
Sorry, but isn't it true that you smoke cigarettes every day?
Objection, relevance, Your Honor.
How's it relevant?
As to be my argument, how she's partially suicidal by smoking cigarettes, and this is why
Okay.
she'd be willing to
No.
mark herself up.
No. Sustained. Next.
So the next question would be along the same lines of that. If you're not going to allow that, then the others do the same thing. So that's all I can think of right now.
All right, can this witness be excused? Do we have any further questions for this witness?
No, Your Honor.
Okay, ma'am, you're excused. Thank you.
And the people arrested, Your Honor.
All right. To prove this case beyond a reasonable doubt rests solely on the prosecutor. Do you understand that?
Comprehend that.
Okay. And you understand that I could not use your silence against you in making a decision on this case. Do you understand that?
Yes.
So that doesn't matter one way or another to me. I would not consider whether or not you testified or whether you didn't testify when making a determination in this case. Do you understand that?
Well, I don't understand. I don't have it. Well, I can comprehend. I don't have to, but I don't know. I don't agree. Maybe the legal aspect, whether it's.
Well, you don't have to agree with it. I'm telling you, as a judge. I just need to make sure you understand that I'm telling you, your refusal to testify would not be used against you. I would not consider it. Do you understand that?
I comprehend that. Yeah.
Okay. And are you waiving that right to remain silent and testifying in this case?
Yes.
Okay. Before we take your testimony, do you have a motion for directed verdict or a motion otherwise?
Yes, but there's an issue of kind of evidence I want to get to kind of support the case too. And being in jail, I don't have access to it, and now the lawyer's not doing his job. So now,
Mr. Martin, you had a bond condition. I want to be clear on this. You had one bond condition that you would not follow. I told you could not return to that residence while the case was pending, and you continued to go back to that residence, and you violated the conditions of this court, and that is why you were in custody. So let's be crystal clear. The reason you had a personal bond. I let you out, and you refused to comply with the conditions of my bond.
I had nowhere else to go to neither.
Well, that's not a me problem, sir. I'm telling you, the reason you were in custody, solely the reason you were in custody, is because you would not follow my bond conditions. So you took away your freedom, because all you had to do was that one thing, and you couldn't do it. So let's be crystal clear on that. Now, did you have a motion?
Yes, I have some. Yes,
your record.
Move to dismiss based on the police officers Duford is not here, and the other one I move to dismiss on that. My right to cross-examine is violated on that because they're not here. So Thorpe, Dylan, and Jeremy Duford, they're not here. So.
Okay. Anything else? The prosecutor has a right to prove her case as she sees fit. And if she wants to bring in a complaining witness and prove that through the testimony of one witness, she's entitled under Michigan law to do so, or any law in the country. So that motion's denied. What else?
Well, I don't have a response to that. That's true as what her right might be, but I'm saying my right to process is being violated. So it's relevant to my right to being violated.
Okay.
Cross-examine.
You made your record. What's next?
Next one is under I move to dismiss under MCL. It's the 28.6D. I'm gonna pull it up on you can refresh your number.
Thank you. I will do that. Go ahead.
It's like section 1. If I remember right, I think go to section 1. I was just looking the other day on the tab of the jail, and I had to hurry up and turn it in so they have a chance to write it down. I'm pretty sure it's section 1. At first, the police is their limitation on arresting, and it mentions, I'm pretty sure it's section 1, where it says they shall not arrest basically unless if they're not aware of a crime being committed right in front of them, they're not supposed to be arrested.
Okay.
So they shouldn't have arrested under that statute, and therefore since they shouldn't have. Now, let me ask you before I get to the rest of my argument. Do you see where it says that in section 1? For 2? It's not much reading. It's right under the, you only have to read all the heading and all that, just right when it gets to the text of the statute. It's referring to police as, like I said, the limits on arresting. They may arrest only in felony cases or if a crime's been committed in their presence, it means they know for sure. Otherwise, they shall not arrest. This statute supports that. They did it anyways, so therefore, I've been illegally arrested.
Okay, I see the statute, I've looked at the statute, and that motion's denied.
I'd like to know the reason.
Okay, Mr. Martin, well, you can appeal me.
I will, and actually, I want to get an appeal form for the request.
Okay, well, you gotta find out what my ruling on the case is before you do that, but any motions or that you've made that I've ruled against you on, will, you potentially can file your motion on those, and we'll make sure we address that, but I'm still taking evidence.
All right.
Anything else?
I don't think so, no.
All right, Mr. Martin, you want to come and take the witness stand? Stand and face me, Mr. Martin. And raise your right hand. You understand you have a right to... Sir, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, have a seat, Mr. Martin. And he does not have an attorney, so I'm going to allow him to just give a narrative, and then you can cross-examine on that narrative. All right, Mr. Martin, go ahead. What do you want the court to know?
Start off, my sister is she's a constant liar.
Okay.
She's very aggressive,
Okay.
psychotic, and to a degree.
All right. Is there anything you want to tell me about this instance?
Well, first we'll start with the general, then we'll go to specifics.
All right. Well, that's character evidence, and it's not admissible, so it's stricken. Go ahead.
And I object to that because it's irrelevant to the credibility.
Okay, it's not. You're talking about her aggressive behavior, right?
Excuse me?
You're telling me she's psychotic and very aggressive, and that really doesn't go to her credibility. That goes to...
Well, yeah, let me argue then to see it.
All right, what's next? What else do you want to tell me?
That's reconsidered after I do my argument.
Okay.
I'll point out it's relevant.
All right.
I wouldn't say things that's not relevant. So even though I'm not an official attorney, I don't have their official training. Studying and practicing law for 30 years, I know it's relevant.
Okay. All right, go ahead.
So basically, on the day in question here, it was relevant to the complaint. Turn the radio down because she had it too loud. The kitty cat was laying right there by the radio. She had it at an uncomfortable level. Turned it up. It was too loud. I turned it down in consideration of the cat. So not stressing the cat. And it wasn't no volume, like low, real low, or too, like she says. It was loud and at a comfortable level. So I do it. She gets all crazy and emotional. You're not going to be turning my radio down and turn it back up. I'll go in your room, mess with it. So I went back in my room. As she said, she was going to my room and mess with something. So I go in my room before her.
Wait, what? Who went to the room first?
I went to the room first.
Okay, and then what?
I mean, after she said it, so she already gave me indication, going in the room, mess with something in my room. So I went in there so I could see, so she ain't doing something I can't see. But so then she followed me in there, like right at the doorway. She came in behind me. And then she's standing right there at the doorway, and then still shouting, you got to be turning my radio down. Whatever, this is my house, and just getting all emotional and crazy. But that's it, basically. And I just turned around and said, get out of my way. She was just blocking my way, but she was all in my face, and trying to instigate me to do something to her, as she normally does, as she did in the last case, which is why they dismissed. They seen on the videos.
All right, I don't care about that case. Keep going.
Basically, just getting aggressive in my face, and I told her to get out of my way. She wasn't moving, trying to instigate me to assault her. But I didn't do that. I just, I had a little leeway, like between the wall and where she was standing. She was standing to the left a little bit, so I just turned my body like this. And since she wouldn't move, I just went aside her. And I didn't push her and do nothing. I went alongside her, behind her, and went to the refrigerator. And that's basically it.
Go out in the hallway. Go in the hallway. Yes, you go in the hallway.
Yeah.
Go on.
I listened to all this lies.
All right. Go on, Mr. Martin.
That's basically it. I went to the refrigerator, and that was basically it. you know, and then I went to my room and she called the cops and that's it, you know, that's pretty much it. And, like I said, basically she lied and didn't do it. They grabbed her, nothing.
All right, so your testimony is you didn't push her, you just walked beside her?
Yeah, slip, like, turn my body like this, and, but I mean, the way she instigates someone, you know, you know, she instigates people to do stuff like that, and then she wants to act like she's the victim, but that's not true, and, as her own testimony, I want to say, admits.
Just,
Yeah,
it's not argument, just tell me what else happened, or whatever, all I want to know about is what happened that night.
Yeah, that's all I have to say that happened that night.
All right, cross.
Thank you, Your Honor. And Mr. Martin, to start, you do understand that you're under oath and under the penalty of perjury, correct?
Comprehend that?
Okay, and yes or no answers if you could.
Yes.
Okay, and you and Lisa Martin are siblings, correct?
What's the word sibling?
Brother, sister.
Yeah.
Okay, and were you both, on the date of June 12th, 2025, you were both at the location where Clipper in the city of Taylor, County of Wayne?
Yeah.
And that's your home?
My home now, well, it's our father's, it was our parents' house.
Do you live there?
I live there, I've been living there all my life.
And does Lisa live there?
Yes.
Okay, and on that day, June 12th, did you and Lisa have a verbal disagreement?
Verbal back and forth, yes.
Okay, and was it about a radio?
Yeah.
Okay, and would you agree that that argument got heated? Were you upset?
Stuff, I mean, back and forth, I'm not sure about the set part, but verbal back and forth, maybe a little bit, you know, but nothing to the degree gonna make me salt her. I know that's what she wants. I know she's gonna call the cops anyway, so I know there's no sense in doing
and
that.
so you're stating no, that it wasn't heated?
I guess every argument maybe to agree might be slightly, but you know, I'm not gonna say it was really heated, you know, I mean, no, I mean, maybe a little bit, you know, but not really, no.
Okay, and was your tone, was it raised?
It was maybe slightly, not too much really, but.
Okay, and you're denying that any physical contact occurred with you and Lisa Martin?
No.
Okay, and you're stating at that time that you were inside your bedroom?
Yes.
And Lisa was by the doorway?
Doorway, like in my room, just barely though, but just like 1 foot inside the doorway. And I walked away a little bit and I just turned right around.
And do you know how big that doorway is? Is it wide? Is it narrow?
I'm not.
Is it a regular house doorway, Mr. Martin?
Yeah, it's regular.
For a bedroom? I
Ain't
saw
no
the
mansions.
pictures of the door and the.
This ain't no mansion, so. But she was standing to the left, right? Just had enough to get by her. Plus, you know, I'm a small guy. I can, you know, stand to the side and I can get by. You know, you see, I'm a pretty skinny guy. I mean, only 140 some pounds. I'm telling you, which for me to get through.
Okay, and Mr. Martin, you're stating that you never touched her at any point?
No.
You never, even walking past the doorway, didn't accidentally hit her or anything?
No. You know, she wanted that to happen. I was standing in the way, but I had enough way to get through and, no.
Okay, and you heard Miss Lisa Martin testify. Do you disagree that this incident took place?
Her testimony is a lie. The only thing she told the truth was about the radio. You know, I turned the radio down.
But you're disagreeing with what she testified to today, that an assault occurred?
Yes.
Okay, and you're maintaining that today?
Yes, and I don't agree that. I'm also testifying that these supposed, they look like blotches on the skin. That ain't caused by no finger pressure.
Okay.
That's.
But you're maintaining that today, right? That didn't occur?
Right, yes.
Okay, and one moment, Your Honor. Mr. Martin, at any point in your life, have you ever been convicted of a crime of dishonesty?
Fraudulently assumed, so yes.
Okay. Was that within the last 10 years?
No.
No, Your Honor.
Okay.
I have nothing further from Mr. Martin.
I have some more things to say.
All right, well, if there was a crime of fraudulent activity and he did testify at some point that there was some crime of dishonesty in his past, it's past 10 years according to both the prosecutor and the witness, so I'm not using any of that testimony and making my decision. Mr. Martin, go ahead.
Yes, also want to say now, the main reason why my sister, keeps up with this agenda of telling constant lies against me, trying to get me with these domestic cases, is because she has this agenda trying to take over the house for herself, hoping the cop would be dumb enough to arrest me like they was. No problem cause, no evidence, just based on her word. And this is the agenda why she's doing it. And then she even had her daughter try this on me too, which that case was dismissed too. This is why there's no evidence. And she knew when I reminded her of it, by the law, you gotta have evidence. You gotta have not just your word, it's not evidence.
Well, your testimony is evidence, Mr. Martin, so.
Well, I said,
and that is, the jury instructions tell me that I can convict based on the testimony of one witness, so I'll follow the jury instructions. But go on.
No, but that's no more than my testimony.
That's correct, sir. You're absolutely right about that.
So, but yeah, so her daughter had tried the same thing. That case was dismissed. So they both try to conspire with each other.
All right, I'm striking all of that. None of that's relevant. What else, Mr. Martin?
I'm just gonna say that's their agenda.
I understand.
That's my sister's agenda.
All right, Mr. Martin, anything else?
No.
All right, are you done?
Yes, Your Honor.
All right, Mr. Martin, you can have a seat. You have anything else you want me to consider?
No, that's what I'm trying to think. I don't want to rush and then forget something unless I'm trying to.
Well, that's all right, Mr. Martin. I think you covered quite a bit here. So you can have a seat back at the stand or at the defense table. All right. And Mr. Martin, are you resting at this time?
Resting? What does that mean?
Well, do you have any more witnesses that you're calling?
Oh. Well, no, I wanted it first, but no, since you questioned her on it, it's not necessary. I was going to, like I said, the tax assessor, but that's good. I'm glad you covered that. I don't need that now, but let me think.
Mr. Martin, you don't
have. Oh, the other video. That's right. It's just reminding me.
All right, Mr. Martin, you can have a seat. Just have a seat. I'll accept that other video, but your brother's not here to testify about that, okay? And I don't really think it's relevant. Do you have a closing argument?
Yes, Your Honor. Your Honor. Today we're here for assault and battery charge, domestic violence count against Mr. Eric Martin. We as the people believe that we have met the burden beyond a reasonable doubt for these charges here today. We did hear testimony from Miss Lisa Martin. This is Mr. Eric Martin's sister. They both reside in the same home. That a dispute occurred over a radio on the date of June 12, 2025 in the city of Taylor, County of Wayne, location being 9074 Clifford. This is both these individuals' home. Miss Lisa Martin testified at some point after a radio was turned down, she approached Mr. Eric Martin's room. Eric Martin he stated to get out of her room. He shoved her once and then attempted to shove her again, but hit her neck the second time. This was unwanted contact by Mr. Eric Martin against Lisa Martin. The testimony believed our witness, Miss Lisa Martin, to be credible. At no point did she change her testimony or change the story. So we believe that we have met our burden today and ask that you find the defendant, Mr. Eric Martin, guilty.
All right, thank you. Mr. Martin, closing arguments.
First of all, the witness is nowhere near credible. They have no credibility at all. As it was evident today by reviewing the video, that my sister made comments several times, it's my house, it's my house. But yet, as she admitted to the judge, the house is not in her name. So it's not her house. That's one lie right there. She's a liar. And her other statement was in the video. I don't know the law. And as she admitted it today in court too, I don't know the law. That's totally baseless.
All right, well, Mr. Martin, you're not She's not charged and you're not charged with not knowing or not knowing the law. This is a domestic violence case.
I realize I'm saying as to her credibility. This is a lot.
Okay, well, Mr. Martin, you didn't go to law school. I don't care if you're personally insulted by your sister saying you don't know the law.
No, I'm not. I'm saying this goes to her credibility.
Okay, well, it doesn't. It doesn't. Because you don't know the law.
Obviously, I made reference that MCR is in here, how my
Okay.
chart.
Anything else, Mr. Martin? Are you ready for my ruling, Mr. Martin? Because I'm ready to rule.
No. Like I said, I got more lies to point out.
Oh, okay. Well, you don't even have to. I'm going to make my ruling. All right. The prosecutor has the burden of proving this case beyond a reasonable doubt. It's the highest standard in criminal law. It's like 96%. The jury instructions tell me I can convict based on the testimony of one witness. Jury instruction addresses that. But I also have to consider jury instruction 3.6 on witness credibility. And there are factors I'm to look at when I determine whether or not I believe a witness is credible. And those factors do not weigh in Miss Martin's favor. There's no doubt she had a memory. She was consistent with her story to some degree. But she evaded questions. She argued with this court. She argued with the prosecutor. She argued with Mr. Martin. I had to tell her on multiple occasions to be quiet. Ultimately, I had to remove her from the court for her behavior. She has no self-control. That was abundantly clear to me. Mr. Martin has appeared in front of me many, many times at this point, and he's a handful and he's frequently disruptive during court proceedings. That doesn't mean that I'm going to take all of that into consideration when I'm determining whether or not someone is guilty of the charge of domestic violence beyond a reasonable doubt. There's no doubt in my mind that people have personal interests involved in this case. And here's the reality. It's very difficult to prove a case based on the testimony of one witness, especially when that witness is argumentative to the extent that she has to be removed from the courtroom. That's just the reality of the situation here. And Mr. Martin, whether or not I agree with him 99.9% of the time, is not what the issue is here. The issue is whether or not the people have met their burden of proving Mr. Martin committed a domestic assault beyond a reasonable doubt. And based on the jury instructions, based on the testimony that I've heard today, I do not believe the people have met their burden. And the case against Mr. Martin is, my verdict is not guilty. Anything else?
Thank you for your just decision.
Well, Mr. Martin, that doesn't mean I think I agree with you on most things, but you don't have the burden today. And that's my ruling. We're all set.
Thank you.
Thank you.
Yeah, she's just a liar. She's trying to just. All right, here. Hold control. Turn around and put your hands behind your back. Right? I told you she's lying. You're gonna arrest her for her lie. That's not it.
ARTIN family. I got the living man blues, yearning to be free. But I'm not that name, 'cause I'm one of the people you see.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell. Also, leave a comment in the comment section. Tell me what you think. And a major thank you to every one of our Facts or Frauds channel members. If you'd like to become a member, just hit that join button right next to subscribe or click on the link in the description.
And for the record, the judge has abandoned court. This case is dismissed.
And if you're still hanging out, thank you. I appreciate you all. Make sure you hit the thumbs up button, subscribe, and ring that bell. Also, leave a comment in the comment section. Tell me what you think. If you'd like to become a member, you can do that too. Till next time, I'll see you soon.